Amit, thank you for giving your time. Please tell me, what were the key takeaways of today's session?
Two key takeaways from today's session are there is a great deal of uncertainty in enforceability of awards arising out of cross-border disputes. For example, disputes between private entities and hybrid commercial entities that are owned by state parties, and that efforts need to be made to clarify the relationship between the New York Convention and state immunity, for example. But a solution that emerged across the various themes discussed today that was interesting was that a lot of the complications that arise and a lot of the fragmentation of enforcement with different outcomes in enforcing the same award in different jurisdictions could be avoided if you draft your contracts properly in the first place. So, for example, if you draft your contract, your BIT contract, to specify that the disputes that arise out of that contract are expressly deemed to be commercial in nature, then it's clear to the investors and everyone concerned that state immunity is being given up and should not be a problem, which gives them much greater confidence and, of course, then invites greater foreign direct investment, which is part of the aim of all this.
Tell me something as an advocate, what are the difficulties in arbitration?
Well,
major challenges.
At every stage, there are difficulties, but one of the challenges that we're still facing in India arises from a duality, Bhumika, and that duality is that arbitration ultimately is about submitting disputes to a person other than a court. But the courts always have to play a critical role in arbitration, and arbitration can't survive without courts. And in India, that's particularly acute because we have primarily still ad hoc arbitration clauses. So one of the challenges that we face as lawyers assisting clients is getting the arbitration off the ground in the first place. With an ad hoc clause, there are challenges to arbitrability, to the appointment of the tribunal on so many grounds. And because courts are overburdened, they languish in courts often for a period much longer than the arbitration itself should have taken. Second challenge is when you come to enforce an award in court, while by and large our courts have moved towards having a minimal supervisory jurisdiction over awards, but still you have to wait your turn. A challenge is filed, court will ask the award debtor to deposit, but then the award holder will have to wait months, sometimes years. Even if the arbitral award is upheld after several years, it really hurts the efficacy of arbitration, and I think these are some of the greatest challenges.
I just have some unrelated question as well. That probably what you have said right now, the courts, how they are giving the judgments. But tell me something. Recently, Delhi High Court has been giving judgments on implied arbitration agreements. That mainly looks like forced arbitration, where the arbitration has always been through consent of the parties. Do you have anything to say on this?
Well, it depends on the facts of the case. The Arbitration Act under Section 7 requires arbitration agreements to be in writing.
Yes.
But of course, you can have arbitration that arises from parties agreeing before a court, for example, to appoint an arbitrator. And you have to balance it, Bhumika. Courts are wanting to be pro-arbitration, partly to reduce their own burden. So I can understand why courts will look to encourage parties to agree to arbitrate even though there isn't an arbitration clause. But at the same time, it's settled that arbitration has to be by genuine consent on both sides.
Okay, last question. If you have to define Delhi Arbitration Weekend in one word, what are you?
Frenetic.
Thank you so much, Amit. Thank you so much.